Hello, my name is Alejandro Osuna. I'm a lawyer in Tijuana, Mexico, with over 25 years' experience in drafting international contracts and in litigating disputes that have arisen from them. I am also involved in international arbitration. I have acted both as party representative and arbitrator in cases involving international joint ventures, franchising, distribution agreements, and construction projects involving the energy sector in cases in Mexico and in the United States. Cross-border transactions can be quite varied. To put it simply, a cross-border transaction is one that has its character, either because the parties to the contract have their places of business in different states, or because performance of contractual obligations is to take place across two or more jurisdictions. A few examples of cross-border transactions include international agency agreements, contracts for the international sale of goods, contracts for the international distribution of goods, international contract for the manufacture of goods, franchising arrangements, corporate and non-corporate joint ventures, secure transactions involving foreign lenders, and construction contracts, just to mention a few. Cross-border transactions can be governed by local, foreign, or uniform laws or principles, and international treaties. Local law will typically apply when parties have not provided for a choice of law clause in their contract, or when a court or arbitral tribunal refuses to enforce such a choice for public policy considerations. When this happens, courts will determine the substantive law applicable to the transaction using its choice of law rules, which are procedural in nature. A conflict of law rule will usually take into account points of contact, such as the domicile of the parties, place of contract formation, place of performance, or the location of assets in a real estate transaction. But these criteria can vary from state to state. Most modern jurisdictions, however, recognize a party's right to choose the law that is applicable to their contract. This choice can address a contract formation, the contract's performance, and the right to receive damages and their quantification. In a cross-border transaction, a choice of law clause is important because it allows the parties to know in advance what rights they will have under the law, particularly with regard to those matters that were not specifically addressed in their contract. While certain jurisdictions may require that the law chosen by the parties have a relationship to the place where the contract is to be performed, or the parties have their place of business, other jurisdictions allow parties to freely choose the applicable law, even if it has no connection to the parties. Most jurisdictions provide that certain rules of law cannot be derogated from, because they address a particular public policy consideration. For example, consumer protection or government contracts. Sometimes a choice of law may not be enforced or recognized when it is found that a law was chosen to circumvent the application of a mandatory provision of law. Parties can also choose so-called soft laws, such as the unit-draw principles of international commercial contracts, a set of principles that parties can incorporate as a body of non-state enacted law, which can be appropriate for many cross-border transactions. An advantage to relying on an instrument such as the unit-draw principles is that it has been published in many languages, including English, Spanish, Italian, German, and they come with commentary explaining the scope of each rule, as well as illustrations showing an example of their application. There is also an important body of case law and of scholarly writing that has been published involving the unit-draw principles. Parties should also note that there are usages and practices that are generally observed in international trade, such as the ICC Incoterms, which in a contract for the sale of goods determines who is to make a contract for their transportation, whether there shall be insurance to protect the goods, and when and where risk of loss is to be transferred. It is important to note that certain categories of contracts already have special laws that govern them. A prime example is the United Nations Convention on Contracts for the International Sale of Goods, which is in effect in almost 90 states. The convention, known as the CISG, is important because it is the default rule in most international contracts for the sale of goods, and it applies to the issue of contract formation and the rights and obligations that emanate from that contract. The CISG has also served as a model for law reform in many countries, and has an ample body of case law of close to 1,000 cases and scholarly commentary and treatises written in many languages. There are many issues that need to be addressed in cross-border transactions. First, I would say that parties should focus on having a well-drafted contract that clearly describes what each party is supposed to perform under it. If a party or his lawyer has had little or no experience in drafting cross-border contracts, drafting one should not be a daunting task. There are many online resources where good templates can be found. A good example are the contract templates offered by the International Chamber of Commerce, which are, by the way, widely used and can be acquired at a reasonable cost. Another great source is the publication Model Contracts for Small Firms, Legal Guidance for Doing International Business. Though published in 2010 by the International Trade Center, it is in no way out of date. It can be downloaded for free, and with some edits, its templates can be used to properly memorialize international joint ventures, international sales contracts, contract for the distribution, and agency, agreements, memorandums of understanding, among others. An important issue when doing cross-border transactions is language. Though English has become the lingua franca for international trade, it is not uncommon to find international contracts that are drafted in other languages. Something that I have personally encountered are contracts that are negotiated and signed in more than one language. In these cases, it is important that the parties provide for a clause which states what version of the contract shall control in the event of a dispute. Parties should also consider addressing the issue of damages, whether to include a clause that seeks to limit exposure or one that seeks to broaden the scope of damages that can be claimed. It is an issue that should not be left unaddressed. Also important, particularly now with the coronavirus pandemic, is that parties consider drafting force majeure clauses that are both clear in terms of their scope and that they are balanced. The International Chamber of Commerce has recently published a 2020 version of its force majeure and hardship clause that is worth considering, at the very least, as a starting point when drafting an international contract. No merchant enters into a contract with the expectation that a dispute will arise. To the contrary, when parties enter into a contract, it is with the highest of expectations that all will properly perform and that their commercial goals will be achieved. Unfortunately, as with anything human, problems are sure to arise. It is therefore advisable that parties that are taking the time to draft a contract for a cross-border transaction address the issue of dispute resolution with the utmost care. So, what are the options? One option is a choice of court clause, but at least one of the parties will feel unsatisfied or insecure with such a proposal because of a perception of bias, or concerns arise from the unfamiliarity with a foreign court system. But even if the parties agree and feel comfortable with choosing a national court to resolve a cross-border dispute, the demands of international litigation will surely frustrate the parties. Most of our courts are backlogged. Their design was never conceived as a vehicle to resolve international cases. The process is rigid and public, and maybe there are issues involving trade secrets that the parties would rather address in a more discreet forum. Arbitration is a far better suited vehicle for the resolution of these cross-border disputes for many reasons. The first is that arbitration is a more flexible process. The parties, in collaboration with the arbitrator, can design the process so that they can better present their case. While the Code of Procedures is rigid and usually contemplates strict periods for the parties to file their submissions, a procedural calendar made in the context of an arbitration can be prepared to provide litigants with ample time for the parties to prepare their cases. Further, because there is no arbitration backlog, cases in arbitration usually are decided at a faster pace than if the same case were taken to a state court. Additionally, in arbitration, the parties have a greater degree of control as to what qualities the arbitrator should possess. For example, the parties may desire particular language abilities or a certain academic or professional background. Another advantage is that in arbitration there is no appeal, making the process more expedient. Moreover, because 163 countries have ratified the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention of '58, this offers a greater degree of certainty that the award will ultimately be enforced. So the other question is, what institution should you use? Well, by far the one with the most experience and that has shown constant growth and probably has the largest overall coverage is by far the International Chamber of Commerce. It is a great institution, very reliable, but there are others that are important at a more regional level. I would say Singapore International Arbitration Center, the China International Economic and Trade Arbitration Commission. If you're dealing in Europe, Vienna International Arbitration Center. These are just to name a few. I think you need to take into account where are the parties located, what are their expectations in terms of choosing a proper arbitration institution to administer the service. But at the end, I think you can't forget about probably the most important piece, and that is the arbitrator. Choose well. Don't think of who can give you an award siding on the side of your case. Think who can be a good case manager and who can actually understand your case. And I think that's probably more important, and it offers a greater degree of credibility and hopefully voluntary compliance with the arbitration award at the end, which is important.